To call this meeting to order, the Plain Township Board of Zoning Appeals for Wednesday, January 2nd, 2019 at 6 o'clock p.m. And we will open this meeting and call to order. First item on our agenda is a roll call vote. So I'll turn it over to Mr. Ferrara.
Mr. Souls.
Yes, here.
Mr. Reichel.
Present.
Mr. Pusilides. Mr. Sutton.
Here.
Mr. Beck.
Here.
And Miss Cernova.
Here.
All right. Next item is to introduce the members of the board. I think all of you have been here before, but I will go through the formalities. My name is Bob Souls. I'm chairman of the board. To my left is Jeff Sutton. To my right is Tim Reichel. And we also have Richard Beck and our new member, Tia Cernova. Correct?
Yes.
Well, welcome aboard.
Thank you.
Okay. Has everyone had an opportunity to read the agenda for tonight's meeting? Is there any changes to come to the agenda?
Yes, there will be a change
Okay.
under new business. We're going to put election of officers.
All right. The statement of the duties are presented at the back for everyone to review, or should be back there for everyone to review. The minutes from December 5th, 2019, do we have a motion to approve those minutes?
I'll make that.
Mr. Sutton, do I hear a second?
Second.
Roll call vote, please.
Mr. Sutton.
Yes.
Mr. Reichel.
Yes.
Mr. Beck.
Yes.
Mr. Souls.
Abstain.
And Miss Cernova.
Yes.
Okay. All right, we have the election of officers for 2019. So we have the chairman, vice chairman, and secretary to elect for 2019. Do I hear a motion with respect to whom we should appoint as chairman for the upcoming 2019 year?
I'll make a motion that we retain all three in their present capacities for the upcoming year.
I second that motion.
And that would be Robert Souls as chairman, Timothy Reichel as vice chairman, and Demetrius Pusilides as secretary.
That would be correct, Mr. Chairman.
Roll call vote, please.
Mr. Sutton.
Yes.
Mr. Beck.
Yes.
Mr. Reichel.
Yes.
Miss Cernova.
Yes.
And Mr. Souls.
Yes. Okay, so we will maintain the same officers for the upcoming year. The appeal this evening is appeal number 1277-18, Stephen Armitage. With respect to that appeal, we do have comments from the fire department, which I'll read into the record. There are no recommendations or suggestions regarding this appeal, and that's from Scott Kelly, the Inspector, Division of Inspections and Investigations. All right, so let's move on to appeal 1277-18. That is Stephen A. Armitage. Is there someone here to present this appeal?
Yes, that would be me.
All right.
I'm Stephen Armitage.
Mr. Armitage, would you please raise your right hand?
Yes.
Do you swear or affirm the information about to present is true and accurate to the best of your knowledge and belief?
I do.
Okay. You would please approach. I think from my perspective, the first item that I have is, with respect to your appeal, that I would like you to address is its timeliness. Because as I understand it, this is an appeal that you have filed from the oral decision of Mr. Ferrara of September 8th, 2016. Is that correct?
I have some exhibits here for everyone. I'd like to pass those out, and I will be happy to address those issues.
Okay. All right, so I would just ask that you address the timeliness to determine whether or not we even have jurisdiction to consider or hear the appeal.
Yes, first of all, good evening to everyone. Happy New Year. I don't know what the record is for most consecutive appearances before the BZA, but I'm about to break it. However,
I think you have.
I think you have.
I think I have. However, I have some good news for you this evening. Based on some things that Dimitrios Poussalides, who unfortunately isn't here, asked me to do since the last meeting, I think there's probably a 95% chance this will be the last time I appear before you, either here or in a court. And I think that will be primarily for procedural and jurisdictional reasons. And I actually don't plan to talk about trees or shrubs or hedges or bushes tonight, because I don't believe, and I'll explain in a few minutes, that this body does have jurisdiction to do that. And in fact, I have two motions in front of you tonight that we'll be discussing. The first one will actually be to have, upon motion of the Plain Township Board of Trustees, dismiss this matter without prejudice for lack of jurisdiction. And I will explain what I exactly mean by that and how I have arrived at my conclusion. The second motion will be to go back to the Denise matter. That's what we called it. Bob, you weren't here last time, but we actually began this appeal in December. So the questions of timeliness and all that were actually discussed back then. But there have been some developments since then that will facilitate some changes. So let me begin. At the last meeting, the last thing that happened was Dimitrios Poussalides asked me to do three things before I came back here. First thing he asked me to do was to document and submit a brief regarding the conflict of interest that I believe this board has, because the attorney for Mr. Farrar and the attorney for the board are one and the same person. And I believe that presents a conflict of interest for this board, and I've given you, like, I think, a 25-page brief on that, which would necessitate this board not having jurisdiction and over this matter. The second reason is a little bit more clear-cut. Mr. Poussalides also asked me to review some cases that came out of Mahoning County, the 9th or 7th District, I don't know which one that is, that actually specifically dealt with this issue. And upon reading those cases, I have come to the conclusion that this board does not have jurisdiction to hear the Stephen matter. Again, for two reasons. The first one is you have a conflict of interest with Baker Dugalkar. The second one is that the cases are very clear, and your own law director gave you an opinion on this actually back in September, which I never saw. Nobody ever gave me a copy of it. The only reason I actually saw it was in the materials that Mr. Matthews gave to me, because I had appealed the Denise matter to the Court of Common Pleas, and this is the record that Mr. Matthews prepared to submit to the court. And in that was the opinion that Mr. Williams submitted to you back on September 25th. And that opinion, and my reading of the cases, is very clear that if you do not have a written decision from the zoning inspector, then there is no jurisdiction for the board to hear an appeal. In the Stephen matter, we never had a written decision for Mr. Ferrero. And therefore, this body, without a written decision in my hand, has no jurisdiction to hear that appeal. However, on the same hand, because I don't have a written decision in my hand, my time for appeal was stayed. And actually, until I get a written decision in my hand, I would have 20 days from that day to file an appeal. So, without that written opinion, I can't file an appeal here, but also my time for appeal also is stayed. So literally, to make a simple example, Mr. Farrar handed me the decision, a written decision tomorrow about what transpired in September of 2016. I would have 20 days to file an appeal, and at that point you would have jurisdiction. Now, if Mr. Ferrera would refuse for any reason to give me a written decision, at that point my only avenue would be go to the Stark County Common Pleas Court or the Court of Appeals and get a writ of mandamus ordering him to give me a written decision. At that point, I would have, again, once I received it, I would have 20 days to appeal and you would have jurisdiction. But because none of those things have happened, I don't have a written decision from him and you have no jurisdiction over this matter.
So are you going to withdraw your appeal?
No, I'm not withdrawing my appeal. I'm asking the board because this is the board's fault. I'm not withdrawing it because I also want my money back. Because you should never have begun this procedure because you have a conflict of interest. and because you didn't have jurisdiction. So my proposal, and you have, by the way, I've given you some proposed resolutions at the end of your packet that I'd like you to consider. Because this is basically, it's a do-over, like we used to say on the playground. This procedure should never have begun. You have a conflict of interest. The only person that can waive that conflict of interest is me. So, starting way back in September, when Mr. Matthews stood up and says, I'm here to represent Mr. Ferrara, the first thing out of somebody's mouth should have been, we have a conflict of interest. Mr. Harness, do you waive that conflict of interest or not? And yet I'd have to do that on the record, and I would have said no, and I've never given my permission to do that. So, but again, there are two independent reasons why you don't have jurisdiction here. And by the way, your own law director agrees with me on the second point, on the written decision part of it. So, and that's consistent, by the way, with a bunch of Ohio Supreme Court cases as well, which turned up in my research, that unless you have proper notice from an administrative body, and proper notice in this case is a written decision, you can't appeal. But conversely, you can't be punished for that. So you can't say, well, you're not allowed to appeal this because we never gave you a written decision, but by the way, your appeal has already expired. It already starts to run. You can't have it both ways. So obviously the courts have decided you can't appeal, you cannot go in front of the Board of Zoning Appeals without a written decision. However, you're not penalized until you get it unless you wait more than 20 days after you physically receive it.
But you're not withdrawing your appeal.
I'm not withdrawing my appeal. I made a motion for you to dismiss, for the Board of Zoning Appeals to dismiss the matter without prejudice.
To dismiss your appeal.
To dismiss my appeal without prejudice, correct.
On the basis that we don't have jurisdiction?
On the basis you don't have jurisdiction, because of a conflict of interest with your lawyer, and because I don't have a written opinion from Mr. Ferrara.
Okay.
It's a limited time offer, you should take it, get rid of me.
Anyone else here to speak in favor of this motion? Anyone to speak against?
I suppose I should go on the record about it. I'm not sure if I'm for or against it. It's just yet another confusing element in the ongoing saga of the Armitage cases. So let me make a couple of points for the record. First of all, I'm Jim Matthews. I'm here tonight representing your zoning director in his capacity as zoning director. And once again, I have to hear that there's this issue of a conflict of interest somehow present that taints the proceedings before the Board of Zoning Appeals. So I guess do we need to develop that? Do I need to address that? And the reason I'm being rhetorical about it is the board going to assume the responsibility of determining whether or not it had a conflict of interest in representation? If it's going to assume that role, then I'll have to address it.
No, I don't think you have to address it.
And I'll just rest on my assertion that there is no conflict of interest. I have never represented the Board of Zoning Appeals in connection with these tree matters at all.
And we understand that to be the case.
And even if I had represented the Board of Zoning Appeals in some prior matter, on some different composition, it would not mean that I am forever barred, or my firm is forever barred, from representation of a zoning official in the township in a matter pending before the Board of Zoning Appeals. So I've made my point. I made it at the last hearing. I won't repeat myself any further. The other points I would make then are directed to the opinion that was very tersely referred to from the law director, because I think the terse comments were inaccurate. The law director did opine that for there to be an appeal to the Board of Zoning Appeals, there has to be a decision. Not that there has to be a written decision, there has to be a decision. The case out of the 7th District that Mr. Poussalides alluded to earlier in the prior proceedings and is commented on in the law director's opinion, went the direction it went because there had not been a request of the zoning official for anything, and there had not been any decision. Whether written or not written, there just hadn't been a decision. In this instance, how do we all know there has been a decision way back, I believe it's in 16 now, that's at issue? You don't have to rely on me saying there was a decision. You don't have to rely upon the appellant saying there was a decision. You can reflect upon what the appellant has offered as part of his record. The Court of Appeals decision which dismissed his mandamus case, that Court of Appeals decision says that the zoning director made a decision in 2016. And 519.14 makes it clear that jurisdiction of a Board of Zoning Appeals is over any order, determination, et cetera, of a zoning official in the administration of a zoning resolution, paraphrasing, of course. It's a different matter. Some of the case law looks at it differently when you're talking about whether there's an appropriate time frame to appeal from a Board of Zoning Appeals decision, and whether or not those determinations should be in writing. That's not the issue here today in this matter. The issue is whether or not there was a decision subject to appeal to you made by the zoning director. And I'm going to remain at the position that there was a decision. That was one of the bases we argued for dismissal of the mandamus case in front of the Court of Appeals. And the Court of Appeals dismissed the mandamus case because that determination had an opportunity to be subject to appeal. So I just think in a case like this, sometimes you just reach a point where you just need to look at the harsh facts, look at the harsh realities, make a decision. If you want to grant the motion, I would respectfully ask that it not address anything alleging a conflict of interest involving me. I don't think this is a proper forum for determining such a matter. If in connection with a court case, the appellant wants to challenge this conflict of interest issue, a court, I know, is properly authorized to make a determination of lawyers appearing before them and proceeding. That'd be fine. I'd litigate the matter there if he wishes to do that. But if you're going to dismiss this, I think it should be a dismissal based upon the fact that this was not a timely appeal. The effect of it, I don't think you have to express whether it was with prejudice, without prejudice. Just dismiss it as untimely, and we'll let the courts sort out what the effect of that is. I appreciate your time again tonight. I didn't expect to have to offer any comments, but as always, I appreciate the opportunity.
Thank you, Mr. Atkins.
If I may, I'll take a little bit in reverse order. The case law is clear that without a written opinion, this court doesn't have jurisdiction. And the case law is also clear that without a written opinion, my period of time for appeal is told. And if you're going to reject the case law, then you're free to do that, but it's overwhelming in this particular area. I will note that I gave you about 50 pages of briefs on this issue. You received, I think, 3 pages of responses from the defendants, which didn't address any of those issues. I remind you this is a quasi-judicial proceeding. I remind you this is an adversarial process. And when one side is asked to submit briefs and exhaustive briefs on the issue and the other side does nothing, I would think presumptively the side that's proven their point should prevail under that. In terms of Mr. Matthews not representing the Board of Zoning Appeals, I would direct you to the exhibit packet you have in front of you. Mr. Matthews, a few years ago, specifically listed himself as counsel for the Plains Township Boarding and Zoning Appeals in a separate matter. That was before the Stark County Court of Common Pleas. His defense to that was that there was a passage or footnote in his brief that indicated that the Board of Zoning Appeals was not technically a party to the proceeding, and as such, he could not be their lawyer. That would fail to explain exhibit number 2, where he signs his name, James Matthews, Baker Jublikar, as counsel for Appalachia Plain Township Board of Zoning Appeals. Would also not explain exhibit number 3, where he indicates this was a situation in which his firm was representing a plaintiff, somebody who had a dispute with Canton Board of Zoning Appeals, and even though Mr. Matthews says it's a mistake to sue the Board of Zoning Appeals because they're never a party, he in fact sued the City of Canton, Ohio Board of Zoning Appeals. I would direct your attention to exhibit number 4. That was my initial appeal of the Nice matter to the Stark County Court of Common Pleas. Exhibit 5 is the response from Mr. Matthews submitting the administrative record, again, in the caption, Plain Township Board of Zoning Appeals. If you actually go on Lexis or Westlaw and type in Ohio Board of Zoning Appeals, you'll come up with thousands of cases where lawyers sue the Board of Zoning Appeals because they're the proper party. Mr. Matthews relies on a 1951 case that was adopted before the Administrative Procedure Act. The cases in Ohio are all over the board. Most lawyers sue the Board of Zoning Appeals. I frankly haven't seen one where they don't. And he clearly did it. When he had to sue the Canton Board of Zoning Appeals, I did it when I had to sue this body, and he has clearly represented in the past that he is the lawyer for the Board of Zoning Appeals. Now, his argument is, well, I'm not that, I may have been in the past, but I'm not that today. Well, that completely ignores the argument that I briefed on terms of enterprise representation. And what I mean by that in layman's terms is that when you represent a parent of an organization, if there are strong affiliations between that parent and its subdivisions, subsidiaries, divisions, or arms, you also represent those bodies. There is no question that Mr. Matthews and his firm have represented Plain Township Board of Trustees for a long period of time. There is no question thus, because of the close connection between the Board of the Plain Township Zoning Commission and the Zoning Appeals Board, that he also represents the BZA. I would at this point remind you that this is a conflict of interest. I have given you supportive documentation that it's a conflict of interest. I have also given you documentation that a judicial body must recuse itself and cannot hear a case when it's represented by the same lawyer as represents the defendant. You have no response from that, from Mr. Matthews. You have specifically Ethical Rule 2.11 that says a judge cannot continue to preside over a matter when the defendant and the judge is represented by the same attorney. And there's no counter brief on that. And again, I take this very seriously. I think this is, at this point, an innocent mistake. It's a conflict of interest. And this board has authority to observe the ethical rules. If I came up here and started making incendiary remarks or using foul language, you could stop me. And you could stop me because I'm not allowed to do that as a lawyer. So what Mr. Matthews, I think, is talking about is certainly you don't have the right to sanction him or penalize him. Only a court can do that. But you can certainly decide that there's a conflict of interest here. And if that's not going to be the decision, at some point, I'm putting the board on notice that I think that's an ethical violation. And I think, in terms of Mr. Williams' letter, I have it right here, as a matter of fact, and you have it as Exhibit 7. And it says, Karochi was based upon a lack of jurisdiction of a Board of Zoning Appeals when no decision was made in writing by the zoning inspector to subject to review. It can't be any clearer than that. The court decided the zoning board did not have jurisdiction because they didn't have a written decision from the zoning inspector. And that's from your
Are you
own.
relying upon that case as well as the Jenkins case?
The Jenkins case and some other cases, yes.
Well, I've reviewed the Jenkins case. The Jenkins case, I disagree. I mean, the Jenkins case specifically had a codified ordinance that required a decision to be put in writing. Where in the Plain Township zoning resolution does it require a decision to be put in writing?
First, you're talking about Mr. Ferrara's decision?
Yes.
Yes, it is specifically, he has to keep a written record of anything that's appealed.
Where does it say that that decision has to be made in writing?
The state Supreme Court, the Ohio State Supreme Court has ruled that administrative decisions must be in writing. This is a quasi-judicial body. The state Supreme Court, as well as the court here in Jenkins, even though it was specifically said it had to be in writing, has made clear that any administrative body has to issue, as does the Board of Zoning Appeals, which it failed to do, in the Denise matter specifically has to be in writing, or you can't appeal it, and the statute of limitations does not run.
Okay.
Okay, no, it's the same, if Mr. Ferrara had handed me a written decision, and I waited till the 19th day and went down to the office and said, I'm appealing this, and I called each one of you and left you a voicemail and said, I'm appealing this, it doesn't matter. It's an oral notification. It's not written. My appeal would be thrown out. So you can't have it both ways. This was an appealable issue. He's required to keep a written record. All right? There was no written record kept in this place because he was a dereliction of his duty. That's not my fault. That's his fault. And therefore, I'm not the one to be punished until I get a written decision in my hands.
And you have means by which to do that.
I do. I can either ask him for it or I can get rid of mandamus.
Okay. Anything further?
Not on this issue.
Anyone want to make a motion on this? I can.
So you're two as well as us.
I will make a motion to deny appeal number 1277-18 as being untimely filed pursuant to section 1201.8 of the Plain Township zoning resolution, which requires an appeal to be taken within 20 days after the decision. And that decision was made orally by Mr. Farrar. Do I hear a second to that motion?
I'll second it.
Discussion?
I'm in here.
Roll call vote?
Mr. Sutton,
Yes.
Mr. Beck,
Yes.
Mr. Reichel,
Yes.
Mr. Solz.
Yes. All right, that matter has been resolved. Next item was a motion to declare as null and void. I believe you filed with respect to Denise Armitage.
Yes.
Decision. Would you like to comment on that?
Same reason. You had a conflict of interest with Mr. Matthews, and your blatant disregard of the judicial conduct standards is, I think, incredible in this particular area. And you leave me no choice, frankly, but to take this matter to the others. And I put you on notice regarding that, because I provided you evidence and you have nothing from the other side. Absolutely nothing. I'm sorry to have to do that. But there's a second independent reason for declaring it null and void, and that is you didn't have a proper quorum by the end of the meeting. You began with a proper quorum, but because of various absences and abstentions, you wound up with only 3 people voting. Of the 3 people voting was Mr. Reichel, Mr. Solz, and Mr. Sutton. Right before the vote, Mr. Sutton made a comment, and let me actually read it to you so there's no confusion about this. And this is from the transcript of the October 5th, October 3rd meeting, perhaps. This was, again, provided to me by Mr. Matthews, so he will vouch for its accuracy. I didn't put this together, he did. And I will on this page. And this is right before the vote was taken. Mr. Sutton, I would concur with that opinion. The dictionaries vary in definitions of the term hedge. The most frequent one says shrubs or bushes planted in close proximity to create a wall, in quotes. In other words, he's saying that somewhere, somehow, he looked at various definitions of the word hedge, and most frequently, maybe over 50%, I don't know what he means by that, the word tree isn't in there. It only says shrubs and bushes. I submitted to this committee 5 definitions of the word hedge, all from 5 different sources, all contain the word trees. Mr. Ferrara and Mr. Matthews submitted no definitions of the word hedge. Therefore, the only definition of the word hedge that Mr. Sutton could have looked at that was in the record were the ones that I submitted to him, and all of them contain the word trees. Therefore, his comments are based either on some outside research or something he saw or thought he saw, It was not part of the record. When something's not part of the record, you're not allowed to make your decision based on that. Therefore, he should have been disqualified at that point, leaving only 2 eligible members, Mr. Reichel and Mr. Souls. However, Mr. Souls should also have been disqualified, because in the very next sentence, or as soon as Mr. Sutton stopped speaking, Mr. Souls said, well, there is a further definition of the word tree as well contained in that. In that, he's referring to the zoning amendment that had a definition of the word tree. Despite the fact that I went into ad nauseum detail in September regarding the fact that the definition of tree was dropped at the November meeting and never made it into the definition of hedge, Mr. Souls relied on that definition, wholly or partly, to reach his conclusion. Again, that definition was not part of the amendment. It was dropped out. There is no dispute about that. So to rely on the definition of tree to determine the meaning of the word hedge was improper, because he was relying on language that was never incorporated into the actual amendment that he was being asked to review. That's glaring error. He also should have been disqualified, leaving Mr. Reichel as the only eligible member. 1 person, no quorum. It's as simple as that.
That's the basis for your motion?
Absolutely.
Okay. Thank you. Chair will entertain a motion with respect to this appeal. Not, I guess I will make a motion. I will make a motion to deny Denise Armitage' motion to declare as null and void the 10-3-18 decision of the Plain Township Zoning Appeals, as this board having no jurisdiction to consider this motion to declare as null and void on the basis of some Ohio Supreme Court authority that provides, absent specific statutory authority or rule, official boards or administrative agencies have jurisdiction to reconsider decisions only until the actual institution of a court appeal therefrom or until expiration of the time for appeal. And I think
Excuse
that
me,
time frame
excuse
has
me.
expired.
Excuse me.
No,
There's something very irrelevant.
No.
No, the appeal has been dismissed. I'm sorry, I've got to get that on the record. There is no
I
appeal.
understand. Yeah,
There is
I
no
understand.
appeal.
It is the, or until the expiration of the time for appeal, and that time frame has expired.
No, it hasn't, because you never gave me a written decision
Okay.
on the Denise matter.
You can sit down.
No, I'm not going to sit down. This is baloney. All right, you're going to let me finish
You
my
can
statement.
sit
No,
down.
I'm not going to sit down.
Sit down, Mr.
No, I won't
Armitage.
sit down, Mr. Reichel. I don't want to, you keep blowing up at me for no reason. You wouldn't even let me
The
finish.
chairman has
statement last
asked you
time.
to sit
I'm
down.
putting this on the record. There is no appeal, and the time limit doesn't start to run because you never gave me a written decision.
Okay. You put that on the record, you put in your record what you filed. I've made a motion. I can hear a second on that motion.
I will second the motion.
Any discussion? Vote, please.
Mr. Beck?
Yes.
Mr. Sutton?
Yes.
Mr. Reichel?
Yes.
And Mr. Souls?
Yes. And there were 2 other motions that were filed. Motion to disqualify Baker Dublicar as legal counsel for Tom Ferrara, and a motion to compel attendance of Mr. Ferrara. I believe those motions are moot based upon the decision that the appeal was not timely filed, so we will not consider those. Okay? Anything further? All right. Let me pull out our agenda. Are there any announcements this evening?
No announcements.
Okay. Motion to adjourn?
Motion to adjourn.
Your second? Second. All in favor?
Aye.
Will I be receiving a written decision of this decision, a written copy of this decision?
It's adjourned. Meeting is adjourned.
I'm asking a question, just as an informal question.
Meeting's adjourned, sir.